Yes, Mr. Burns, please continue.
Good afternoon, my lords, my lady. If I could turn back to 324 in the electronic bundle. Don't know if that's where you are already.
Yes.
Back to the language of the section. The Court of Appeal's interpretation correctly reflects the use of two future tenses in the section that Mr. Seagull addressed in part. The errors of the EAT majority and the tribunal was to interpret prohibitive result as meaning that one or more terms of the worker's contract are immediately, on acceptance of the worker, agreed directly rather than by collective bargaining. The proper interpretation, the one the Court of Appeal arrived at, is whether the terms after acceptance by the worker will not or will no longer, future tense, be determined by collective agreement negotiated by on behalf of the union. And the important thing here in the words is to see the two future tenses, one in section 145B1A and the second future tense in section 145B2. The first level future tense is in subsection 1A. Acceptance of the offer would have a prohibited result. So would directs the focus in the future to the moment of acceptance. So the question is, statutory question is, looking forward into the future from the time of the offer to the moment of acceptance, would that acceptance have the prohibited result? And then the prohibited result in subsection 2 has a second level of future tense. At the moment of acceptance, will the terms be determined by collective agreement, or will they not be determined by collective agreement? The statutory question is, at the moment of acceptance, how will the workers' terms be determined? How will they be determined? Not how are they determined, or how have they been at that moment of contractual acceptance, how have they been determined, but how they will. The statute focuses correctly on the state of affairs after acceptance. Court of Appeal's interpretation means that will no longer is given proper effect. The EAT's interpretation removes any statutory effect from the words will no longer, because any change to any terms, the EAT said, offends section 145B, whether or not those terms will no longer be determined by collective agreement. And so that's why I say that the claimant's approach does interpret section 145B2 as if it says are not or are no longer. There's only the one future tense, and that's the way that the EAT tried to explain it. Mrs. Justice Simler said I was making too much of the future tenses, because she said because it's about an offer, it will always look forward to the future. Well, that's to forget that 1A deals with that, looking forward from the moment of the offer into the future to the time of acceptance. And what we're looking at is the second future tense in section 145B2. Question, the statutory question is very straightforward. At the moment of acceptance, how will the terms of this worker's contract be determined? Will they be determined by collective agreement or not? The EAT also said that my submission was wrong in saying that the words will not or will no longer have laden within them will not in the future or will not in the future. The EAT said that there was no need to read in additional words. I say there is no need to read in additional words. Will not always means will not in the future. Will no longer always means will no longer in the future, as a matter of ordinary language. So that's why I say the Court of Appeals analysis is correct just on that careful reading of the future tenses. Lord Delegate.
Couldn't the no longer refer to a situation where there's already been a collective agreement reached, but after that the employer then sends out individual letters inviting people to enter into a different agreement, which, if they accept, will mean that some of their terms will no longer be determined by the collective agreement that's been reached?
Yes, that's exactly our case. That is the paradigm example of this. It's where terms, some of the terms or all of the terms of the contract of employment are determined by collective agreement, by collective bargaining, and the offer, if accepted, takes some of those terms out of the scope of collective bargaining. It takes some of those terms away from the collective bargaining arrangements. It narrows the scope of the collective bargaining. That is the paradigm case. And the second, and very much more unusual case, is where there are no collective bargaining at the moment, but there's a union which has ambition to be recognised for collective bargaining. It's made perhaps a request of the employer to be recognised for collective bargaining, which hasn't yet been agreed. And the employer makes an offer to the workers to say, if you accept this bribe, this inducement, your terms will not be determined by collective bargaining. And the employer say yes. And then even if the employee, the union is recognised, then for those employees, for those workers, for those terms, the collective bargaining process won't apply. And that then reduces the scope of the collective bargaining. It reduces the seat at the table that the union has. That then moves me on to section 145D, which is at page 328.
Just before you go there, couldn't the reverse be said, namely that the words will no longer are to prevent an employer from making an offer which will disapply the collective bargaining on one occasion? Because the employer might then be able to say that the prohibited result is not met because in the future there will still be collective bargaining. It's just one occasion. Once you make it will not or will no longer, the expression will not must cover the one-off as well as the future.
If the offer is to disapply collective bargaining for any period of time, in my submission, that is what section 145B was aimed at. I don't say, as Mr. Siegel says, that it needs to be permanently. Let us say that the employer says, if you accept this £500 bonus, there'll be no collective bargaining for the next 12 months or the next 6 months, because the employer knows that it's about to go through a particularly rocky time, or that the union's got particular power, particular influence at that time. That would be a breach of section 145B, because it would be taking some of those terms out of the scope of collective bargaining. It doesn't matter whether it's taken out for a temporary period or until the union can get it back. In some ways, in relation to employment contracts, saying anything is permanent is a little odd, because they only last for as long as they last, employment contracts, until employment terms last until you change them.
Sure, but if you do not have the words in parentheses, and note they are in parentheses, not to be, as it were, the main part, the main expression. If you didn't have the words in parentheses, might not it be argued that the words will not are only met if the change is permanent?
The matter is judged at the moment of acceptance, And so the question is the effect of acceptance that pay will not be determined by collective bargaining?
And the employer says, it's just this time, just this August bank holiday, I got a big contract, time limited, got to get the stuff out. Therefore, there'll be special terms for this bank holiday, bypassing collective bargaining. And he'll say, well, that's not going to be a prohibited result because we're going back to collective bargaining. It's just this one-off.
Well, the inquiry is whether or not if the worker is denied his rights of collective bargaining for even a short period, that's what section 145B is designed to protect. It's if the employer says, if you accept this bribe or this bung or this £500, pay will not be determined by collective bargaining. We're not going to do any collective bargaining for the next 6 months. That reduces the workers' rights. That is what Wilson said was unlawful. It removes the union's right and the workers' right to have a seat at the table. And that's the mischief that I say the Act is aimed at. And it doesn't matter, I say, whether it's for 3 months or 6 months or until the union can get the bargaining rights back. The mischief of the Act is to stop an employer making an offer to the workers, which induces those workers to give up their collective bargaining rights for some period. And so will not means that at the time after acceptance, those terms will not. The reason the words will no longer are in there is because, as I'll show you in a moment, they were the original words in the bill. The bill originally said, recognised unions will no longer be determined. It was pointed out that will no longer meant that unions seeking recognition were not covered, and they ought to be covered because that was part of the purpose of the Act, was to try and encourage unions that wanted future collective bargaining to be able to not have a block put in the way. And therefore the words will not were added, and I think then probably for reasons of linguistic elegance, will not brackets and will no longer were added in, the brackets were added in order for that phrase to flow.
Yeah, thank you. I understand that, but of course that went on within Parliament, and there may be some question whether we can look at it. That is the result of the recommendation of the Human Rights Committee, wasn't it?
So Lady Allen, perhaps I'll take you to this in order so you can see the progression from where we went to. It was at a fairly late stage in the bill's development that it was pointed out that the bill was perhaps deficient in not giving the full protection that it ought to, and that's when the words will not were added in. But perhaps if I take you in order, you can see the progression. Mr. Siegel has dipped into the pre-enacting history a little, but I just wanted a little while to show you the full.
If we're entitled to look at what the Minister said on this, we are entitled, I suppose, to look at the whole of the Human Rights Committee's report. That was before Parliament, isn't it?
Certainly, what I say is important to look at is and what's admissible as part of the enacting history is the case law, which its common ground led to the enactment. Secondly, the government's stated proposals for bringing the enactment to Parliament. Third, the words of the draft bill that were brought to Parliament and the change that was made to it. And then the Hansard reference effectively explains why the change was made and explains why we have will not or will and will no longer.
And are there no explanatory notes on the bill as opposed to on the Act?
We have only got the explanatory notes on the Act. I don't know whether
there normally are.
I will check whether there was explanatory notes on the previous bill.
Yeah,
but it's Lady Anne, I think it's tolerably clear, and possibly it's even common ground, that until the amendment, all of the reports and the minister's words all talked about recognised unions. Where there's a member of a recognised union will no longer have his terms determined by collective bargaining, and then the words came in: recognised unions or unions seeking recognition will not or will no longer.
Yes, I mean, there may be wider reasons for looking at the explanatory notes on the bill, because the explanatory notes on the Act refer to the 2003 government response. It might be relevant to know what Parliament was told at the time.
Lord Burrows.
Thank you, Mr. Burrows. I just want to take you back to a submission you just made. In effect, I think you said that even a very short temporary suspension of collective bargaining rights would fall within the mischief of section 145D. And I've got two questions in relation to that. First of all, is that consistent with the Court of Appeal's reasoning, where they were drawing a distinction, I think, between permanence and on this occasion? And then secondly, why wouldn't one say that the facts of this case might be said to fall within that? Or are you going back to the point you made to me before lunch, that ultimately there was a collective bargain reached in this case, but it was certainly over a long period of time? I mean, you could say it was suspended for a period, couldn't you, on these facts?
No, on these facts, collective bargaining was protracted, as it often is. So certainly, in my industrial experience, collective bargaining is rarely done within a few weeks. The industrial parties in this contract were ambitious. They said that collective bargaining would start in October and would be completed in December, ready for January. That was a short period of time. Collective bargaining often goes on for many, many months, and indeed often goes into the following year and sometimes continues for a while afterwards. In this case, collective bargaining was not suspended at all. Collective bargaining started in October. It finished. It was completed with the employer putting forward an offer in response to the union's demands. The union then considered that. They didn't advise their members to accept it. Their members didn't accept it. At that stage, the employer could have said, collective bargaining is now finished. There's no need for any more meetings. I've done my collective bargaining. But in this case, what the employer actually did is saying, well, let's have another go. Let's start the collective bargaining again. And it had another meeting in December. And then we know that collective bargaining continued during 2016 and resulted in finally a collective bargaining agreement reached in November 2016.
Wasn't that, I mean, there was also industrial action during the course of that year.
There was an overtime ban, which the union used its ability, its Article 11 rights were to have a seat at the table, to engage in the negotiations, to try and persuade, but also to try and bring industrial pressure to bear by the industrial action.
And can I just, if I may at this point, can you just explain to me, at what point would the ACAS fourth stage kick in, and why didn't that kick in here? Is there any obvious reason that we need to know about?
So it's because it's entirely voluntary, Lord Burrows. If you look at 274 in the main bundle, you'll see that after the collective bargaining is completed, there's a disputes resolution procedure, which has 4 stages. The first stage is that the senior trade union representative will meet with the relevant manager within 3 days. The second stage is that, failing agreement, the senior trade union representative will meet the site executive management within 5 days. And stage 3 is that, failing agreement, the senior trade union representative will meet the site managing director and executive manager of HR within 7 days. Stage 4 is, failing agreement at stage 3, the matter by joint agreement may be referred to ACAS. So the procedure that was agreed by Kostal and Unite was 3 stages that you needed to go through for the dispute, well, which you agreed in a non-binding, non-legally enforceable agreement, but you agree effectively what we would used to be perhaps called, in pejorative terms, a gentleman's agreement, or agreement binding in honour only. They agree to go through 3 stages, and then they can, if they want, there's an agreement to agree, go to ACAS. There was, I think, discussions about going to ACAS, but the party didn't agree to go to ACAS.
Were any of those stages undertaken?
Stage 1 to 3.
Right. Thank you.
I think the trade union representative met the managing director. The managing director. So,
just coming back to my original first question, I'm sorry, just in case it's lost, but the Court of Appeal, is what you're saying consistent with that?
Yes, absolutely. Mr. Seagull suggests it's part of the ratio that the Court of Appeal was saying that it had to be permanent. That's not what they were saying. And you can see that from the Court of Appeal judgment. So I've just lost it. One moment. So in
You're on page 142, are you?
Yes, 142. There is first of all, there's paragraph 50. First type of case is where the independent trade union is seeking to be recognised, and the employer makes an offer whose sole or main purpose is to achieve the result that the workers' terms of employment will not be determined by collective agreement when that collective agreement is reached with the trade union seeking recognition. That was the one that was made by the amendment. Second type of case is where the trade union is recognised and no longer, and what the Court of Appeal says there is, no longer clearly indicates a change taking the term or terms concerned outside the scope of collective bargaining on a permanent basis. That corresponds with the use of the word surrender in Wilson. So that means that from the moment of acceptance, there is no longer collective bargaining until it comes back. So it's permanent in the sense that the union are going to have to persuade the employer to give it back. Yes, I accept that the words will no longer do have a connotation of permanence about them, long-term about them, but it doesn't need to be long-term, and nor does the Court of Appeal say, because the Court of Appeal is looking at the third difficult case, which is what the claimants contend for, which is where there's a recognised trade union. The workers' terms of employment, this is paragraph 52, are determined by collective agreement negotiated on behalf of the union, and the employer makes an offer whose sole or main purpose is to achieve the result that one of the workers' terms will not, on this one occasion, be determined by collective agreement. They will longer be determined by collective agreement. They will in the future be determined by collective agreement, but just the scope of collective bargaining won't be changed. But just on this one occasion, they won't be determined, and for the reasons given in paragraph 53, the Court of Appeal say there isn't, Parliament didn't intend the words will not to apply to the union which is recognised, only intended will not to apply to unions seeking recognition.
Mr. Burns,
yes.
Just before you go on, I'm sorry, we've been all asking you a lot of questions, but I think we're about to get into some detail of travaux préparatoire, unless I'm much mistaken. Just on the meaning of section 145B2, your futurity argument, as I understand it, is essentially based on the proposition that the moment of testing is the moment of acceptance. Is there an alternative view that the moment of testing is the moment of the offer, because that's what constitutes the breach of the employee's rights not to have an offer made, and that the futurity lies in the fact that the prohibited result will only be achieved when, or rather if, in future the offer is accepted?
So yes, I think that's another way of putting my submission, which is that you're absolutely right. The unlawful act is the making of the offer. The offer is only unlawful if it would in the future have an effect. And the effect in the future is that at that point in the future, terms will no longer be determined, or terms will not be determined. So yes, you're absolutely right.
Well, I'm not intended to make it so helpful for you. Why cannot on that analysis that you're standing and looking from the point of the offer, will simply refer to the fact that inevitably the acceptance will take place after the offer?
because that's what would is for in section 145B1A.
Well, wood's in the
Because you have
subjunctive. Wood's in the
Yes.
subjunctive because it's conditional upon acceptance. But you're out of the subjunctive in 2, and that's why it says will rather than would.
But acceptance of the offer has the prohibited result. The prohibited result will be determined, would only have one future tense in it. If acceptance of the offer has the prohibited result, would be a way to do that. We've got would rather than has. Lord Leggett.
Sorry to delay you further, but my question, I think, will bring you back to where you got to. You're about to take us, I think, to the drafting history, and I would find it helpful at some point, if it's not in the bundle, then after the hearing, to have some authority on whether it's admissible, given that, for example, in a contract, you can't look at earlier drafts to infer what the final version meant. But can
Yes.
you can in a bill, then I'd like to see that.
I'll take you to
My
that
reason
in a
for
moment.
saying that is that unless we refer to it, I don't see much to commend your argument just on the face of the wording, given that there's no obvious connection between the tie-up between the alternatives in 1 and in 2. I mean, they're the wrong way around for a start. And as my lady says, it's in brackets, the or will no longer. And if that one was meant to be tied to one and the other to the other, you might expect it to say, in the case of a union seeking to be recognised, will not, and in the case of one already recognised, will no longer. But it doesn't say anything like that. So on the face of it, either one could go with either, insofar as it's applicable.
I accept those points, Lord Beckett, and indeed, it was only between we weren't able to find the draft bill at the time when we were in the Court of Appeal. It's actually only subsequent to the Court of Appeal that we've actually been able to find online on the Parliamentary Library the draft bill. And I will take you to the authorities which say that the draft bill is a permissible and indeed a helpful tool of statutory construction. Before I go to the enacting history, I wonder if I could just go back to where I was a moment ago, which was section 145D, just finishing with the words of the actual statute itself on page 328. And the importance of section 145D, we say, is that when you look at 4A and B, the factors that the tribunal must take into account, and this was a question I think that was put to Mr. Seagal earlier, why are these factors the ones that the tribunal must take into account? And the answer is, we say this, that in A and B, the focus is on arrangements. Has the employer recently changed collective bargaining arrangements? Has the employer sought to change collective bargaining arrangements? Does it not wish to use the collective bargaining arrangements? And in B, when the offers were made, the employer didn't want to enter into arrangements, future arrangements. So the focus on section 145D is it's impermissible, it's the prohibited result, and the employer intends the prohibited result where the employer doesn't like the arrangements. That's where the employer doesn't want to use collective bargaining arrangements. It wants to take terms out of those collective bargaining arrangements so it doesn't have to use them in future. So section 145D is consistent with an employer whose prohibited result is taking the terms out of the collective bargaining arrangements and whose intention, whose purpose is to take the terms out of the collective bargaining arrangements. So the question of the prohibited result is therefore, if one looks at section 145D, will acceptance of the offer take that term outside the arrangements, or is that term still in the arrangements? And in Kostal's case, pay and Christmas bonus and working time and all the terms that were being negotiated were still within the arrangements. The union had absolutely the right to raise them as it did in December and in 2016.
I think Mr. Seagal's more powerful argument, at least at the moment, to my mind, is that what's the point of having the purpose test at all on your view of the prohibited result? But surely it's just a matter, really, of looking at what was offered. And if what was or being proposed was that you should be, you're being asked to opt out of the collective agreement process, then why have what good does a purpose test do on top of that? I mean,
well, Mr. Seagal, I think, possibly knows exactly what the test is for, and it's a real and there's plenty of examples in real industrial bargaining. One, I'll deal with it hypothetically. It actually comes from the facts of an actual tribunal case, is where an airline, British Airways in this case, moved its staff in Heathrow from being supervisors and turned them into managers. Moving the supervisors and turning them into managers took them outside of the supervisors' collective bargaining arrangements. The offer had the prohibitive result. It meant that those supervisors were no longer covered by, or those new managers were no longer covered by supervisors' collective bargaining. They were covered actually by managers' collective bargaining, but it was a different collective bargaining. And BA were able to say, and succeeded in saying, yes, the offer took the ex-supervisors outside the scope of this collective bargaining, so that not all of their terms were going to be determined by collective bargaining in future. But that wasn't our purpose. Our purpose was not to take them out of collective bargaining. Our purpose was to transfer supervisors into managers. And let's look at section 145D. We didn't want to change the arrangements for supervisors. People who stayed supervisors, they would carry on being covered by collective bargaining. They hadn't recently changed collective bargaining arrangements and so forth. And so section 145D unlocked the defence in that case, because the purpose of the employer was not to get rid of, was not to change collective bargaining for those people. And there'll be plenty of circumstances in which the employer makes a change to its organisation, shifting grades or transferring people from different workplaces or moving them to different teams, where they might go outside of a collective bargaining unit. Let's say the collective bargaining unit is the maintenance team, and the employer has a reorganisation, and so some of the people who were in the maintenance team are moved into a different team, and therefore they fall outside the collective bargaining arrangements for the maintenance team. But the employer will say, I've got no intention or purpose to change the arrangements. My purpose is all about just moving these people to where they need to be. So there's plenty of scope for section 145D to have full force. Before we leave the words and go to the enacting history, could I just go back to section 145B, page 324, and let's just take the example of the union seeking recognition. And let's work through the words for a union that's seeking recognition, because that's covered as well as a recognised union like Unite in this case. So in such case, the worker who's a member of a trade union seeking recognition has the same right not to have an offer made to him by his employer if acceptance of the offer together with other workers' acceptance. And can I just perhaps just pause there for a moment and say the reason that other workers are mentioned is that this is a collective provision, and therefore there needs to be multiple workers rather than just one. Going back to the union worker who's the member of the union seeking recognition, the acceptance of those offers would have the prohibitive result. So the union's not yet recognised, so none of the terms are yet determined by collective agreement. The offer must not have the prohibited result. The prohibited result can only refer to the future scope of arrangements that are yet to be entered into. the future scope of collective bargaining when the union comes to be recognised. The prohibitive result cannot mean how the terms are determined at the moment of acceptance. It must refer to an offer which takes the term or terms outside the scope of collective bargaining in the future, when the union is recognised and starts collective bargaining. Now, the prohibitive result must have the same meaning whether it's applied to a recognised union or a union seeking to be recognised, or the workers or members of either. That, in my submission, conclusively shows that we are looking at future determination and not determination at the moment of acceptance. It must mean will not in the future. It's only regulating offers which affect the scope of collective bargaining after the offer is accepted. So the section just, sorry, yes, Lord Legate.
Is that the only possible interpretation? Might it not work that if the union is seeking to be recognised, then you cannot send out an offer, in effect, that would not go through a collective process without risk of or you will achieve the prohibited result if you do.
So if the, so I don't quite understand the question, Lord Legate, sorry.
Well, sorry, the union is seeking to be recognised.
Yes.
It wants matters, therefore, to be subject to collective bargaining. You cannot, in that situation, make an offer to the workers regarding their terms of employment without achieving the prohibited result, essentially. And the only way of avoiding that will be that you recognise the union and bargain with them collectively.
The point is this, that where a union says to the employer, we seek recognition for collective bargaining, what the employer could then do is send out an offer of new terms to the employees saying, if you accept these offers, we will give you £500 if you agree that these terms will not be the subject of collective arrangements or collective bargaining. So effectively, take it out of collective bargaining before nip it in the bud, before it even happens. So that's the evil that's aimed at. It's
well, I understand you say that obviously it does cover that, but you're saying it can only cover that. And I'm suggesting to you that at least a possible interpretation is that it does more than that. And it says that if you send out in that situation an offer inviting all the workers to accept it individually, then, and you, before you have recognised a collective bargaining arrangement, then you've achieved the prohibited result. You're then into what your purpose was.
So the prohibited result, yes, you will have achieved the prohibited result because the terms will not be determined by collective bargaining when collective bargaining starts, because the employees have agreed to exclude pay or hours from collective bargaining.
No, just because they've accepted the 6% pay rise for this year.
Okay, if they accept 6% for this year, then when the union says we want collective bargaining over pay, and if the employer says, oh, yes, I'll volunteer to collective bargaining over pay, then all the people who got 6% will be part of that collective bargaining. And so the 6%, the pay will be determined by collective bargaining. So the prohibitive result won't have been achieved because there'll be nothing to stop. There'll be no reduction of union rights. There'll be no reduction in the scope of collective bargaining. That will be any offer. I mean, that would be any normal offer. So, of course, employers have got to carry on making pay rises whilst they're waiting for the union to get itself organised to seek recognition. Plainly, they've got to be allowed to make 6% pay offers. The only thing that the section prevents them from doing is making an offer which stops that pay being part of the collective bargaining when the collective bargaining comes in, and because that would reduce the union's rights and the workers' rights and would be the mischief, the Wilson mischief that the section's aimed at.
It seems to me you've got two arguments in play, in fact, Mr. Burns, alternative arguments, if I understand it right. I mean, looking at the no longer situation, your primary point is that no longer has to be more than just what's agreed now, as it were, and it's
Yes.
looking to the future. But it seems to be an alternative argument you first put forward in answer to Lord Barrows just before lunch, was that as long as the employer is prepared to carry on some form of collective negotiation, which could at least alter what's just been agreed with all the workers, then you don't fall foul of the section anyway.
Yes, because I mean, you could see in this case, what is it that wasn't put to the union? The same offer that was put to the union was put to the workers after the collective bargaining offer had been rejected by the members. What the iniquity of this is for the employer to put to the workers something that is different or better, possibly worse, than is put to the union. This is a case in which the offer that was put to the union and to the members is exactly the same offer that was put to the workers directly. And so effectively, this is an offer which is in parallel to, it's compatible with collective bargaining, it's consistent with collective bargaining. In the Kostal case, it wasn't an offer which undermined collective bargaining. It didn't give a different offer. All that it did do was undermine, in Mr. Seagull's words, the union's mandate, because they said our members won't settle for 4%. It's outrageous. They then rejected it after a ballot. The employer then put it to all the workers, all 700, and as Mr. Seagull said, the workers, including the trade union representatives and the trade union members, accepted it. And the union representative then said, well, you've cut the ground from beneath me because people have voted with their feet. To which the employer said, yes, well, you're the union, you're supposed to represent the voice of the workers. Well, the workers have spoken. So our submission is that in this case, in Kostal's case, what Kostal did was compatible with collective bargaining, and what the union was doing was just making an unreasonable demand, which they ended up looking a bit silly because the workers, indeed their members, accepted it, even though they'd said in the collective bargaining that it was unacceptable. If I can, I'll move on now to, so that's just dealt with the reason that it must be in the future, because the section wouldn't work otherwise for unions seeking recognition. Mr. Seagull did mention in his case a rather strange interpretation, which is to say that some terms will not is for when the terms are new, and will no longer is for when the term is an existing term. So, for instance, but if terms and conditions are bargained about, then whether the 6% offer is a new form of pay or whether it's a new bonus, pay is still bargained over, and so it won't take pay out of the scope of collective bargaining, and so will no longer would still be apposite. Will no longer is only not apposite where there is no collective bargaining about those terms at all, because the union is not recognised for collective bargaining either at all or recognised for collective bargaining about those terms. You can imagine a case in which unions only have collective bargaining for, let's say, just pay, hours and holidays, but nothing else. And in that case, the employer makes an offer to the workers to say, pay, hours and holidays remain in collective bargaining, but if you accept this £500, everything else remains outside collective bargaining. That would be an offer to induce those workers so that they will not in future be collectively bargained, even if the union tries to expand collective bargaining to be pay more than pay terms, hours and holidays. And so will not is only for where the union isn't recognised, i.e. at all, or for those terms. Will no longer is where the union is recognised. And I'll show you that in the enacting history just now. Let's turn first to the to Wilson, and in some ways it may be useful to go to the respondent's case and follow this argument through, so I can go through it a little more quickly. It begins at page 78. And paragraph 15 of our case, you'll see that, first of all, it's accepted by both the parties and the EAT and the Court of Appeal that the Wilson is the case which caused Parliament to act and to intervene. We start with the fact that Wilson is the case, as Mr. Seagull accepts, one in which the workers were offered inducements to relinquish collective bargaining. That's Wilson, paragraph 47. So the word relinquish, I draw your attention to, that's used later in the enacting history.
Surely it's not a question of what the case decided if Parliament took the view that it decided rather more.
Lady Arden, I agree entirely. Parliament could have done Wilson Plus, and indeed it did do Wilson Plus, and I'll explain to you, well, it didn't just ban inducements to stop collective bargaining, it induced inducements to not use union services. It banned, made unlawful inducements not to become a trade union member, inducements not to take part in trade union activities. So it went wider than just Wilson. Wilson was just about relinquishing collective bargaining. The Act, section 145A, and also amendments to section 146 made up the other things, because Parliament did say we're going to go wider than Wilson. But we say that 145B is the bit that is Wilson specific.
Yeah, so unlike the other amendments, it's not Wilson Plus.
So section 145B is Wilson, section 1456 is Wilson Plus, yes. The Wilson, as Mr. Seagull said, its common ground is based on the Article 11 European Convention of Human Rights, right to collectively bargain in the way that you've got a right to be informed and consulted. I agree. You've got a right to negotiate collective bargaining. I agree. You've got a right to strive for your members during that bargaining. I agree. You've got the right to the union's voice to be heard during that bargaining. I agree. You've got the right for to make and accept and reject offers. And in this case, in Kostal's case, we had the union being consulted, negotiating, discussions. We had the to and fro during October and November. We had an offer made to the union, and the right to consider that offer and reject it. So all of the ingredients of collective bargaining were present in this case before the first and second offers were made by Kostal. Wilson is anti-trade union discrimination. And as we say in paragraph 18, employees who are not prepared to renounce a freedom that was an essential feature of union membership. So we say that that really does inform the correct construction of section 145B, because section 145B is there to protect employees so that they're not induced to renounce a freedom that's an essential feature of union membership. And that's where I started in my submissions, because I say the essential battleground here is that the essential feature of union membership is the right to collectively bargain, the right to be heard. Mr. Seagull says that it's the right for the union's mandate not to be undermined. That's different from the collective bargaining. What our submission is that it's absolutely perfectly fine for an employer to use tactics to strengthen its hand in the industrial to and fro. it's perfectly fine for the union to use tactics to strengthen its hand in the collective bargaining toing and froing. It's perfectly fine for the employer and the union to try and undermine the other side's mandate. What it's not fine, and what section 145B is about, is something that requires a worker to renounce a freedom, an Article 11 freedom. So this isn't about the union's mandate, this is about the union's seat at the table. That's the conduct in passage quoted at paragraph 19 on page 80, the inducement to relinquish the right to union representation. In Kostal's case, did any employee relinquish their right to union representation? No, they didn't. They all retained their complete rights to union representation. All that happened in Kostal is that unions' persuasive powers was undermined. The Wilson also concluded, and we have the word surrender. That's paragraph 23 on page 81 of the respondent's case. Wilson concluded, by permitting employers to use financial incentives to induce employees to surrender important union rights, respondent state failed to secure the enjoyment of the rights under Article 11 of the Convention. That's as the loophole that section 145B was enacted to close. So I draw attention to the words relinquish and surrender used in Wilson, and you'll see them used again. If we, perhaps if I come to the authorities under which the court is entitled to look at the enacting history. If you could turn in the main bundle to page 499. That's R and Montia in the House of Lords, 2004, 1 weekly, starting at page 3141. And you'll see it's got nothing to do with the facts of this case. It's offences under the Criminal Justice Act and the Drug Trafficking Act. Held on page 499, the headings and side notes were as much part of the context of an Act of Parliament as explanatory notes, which were admissible aids to construction. And there was no logical reason why they should not be treated differently. That account had to be taken of the fact that headings and side notes were included in a bill, not for debate, but for ease of reference, which indicated that less weight should be attached to them than if parts of the Act were open for consideration and debate in Parliament. And that while subject to the fact that headings and side notes were unamendable on a passage through Parliament, they ought to be open to consideration. And if you turn to the next is Benyon, which is at page 625 in the main bundle. 625 is reports leading up to bill and draft bills. It may be useful just to go to 627 on draft bills. Sorry, consultation papers on 627. At the top of the page, 627, we have consultation. The fact that a report is a consultation paper does not affect its admissibility, at least for the purposes of ascertaining the contextual setting of the legislation or the mischief at which it was aimed. And examples are given there. Draft bills, as may be seen from the above discussion, when considering an act that's based on a draft bill, reference may be made to the commentary that accompanied that bill. A related point is that in appropriate cases, inferences may be drawn from the differences between the text of an act and a draft bill on which it's based, especially when those differences are considered in the light of other factors. This potential use of draft bills was mentioned by Mr. Justice Bean in Cook and MGM. I also considered in the parliamentary history, and in particular, any respects in which the act differs from the original draft bill might be highly illuminating. We also have in that section reports and Law Commission reports and we go on to, if you look at weight, bottom, perhaps if, my lords, my lady, you could read yourself, bottom page 627 and just over the page 628. So looking first at the 2003 government response, which is dealt with in our case, I can deal with this fairly quickly. It's at page 303, and the relevant passages are at page 311. And I invite you to read 3.9. In fact, perhaps if I just take you through 3.9, you see that the government response required important changes to trade union law, especially the law outlined discrimination, union membership and activities. Though the incidents which gave rise to Wilson and Palmer are less prevalent in today's climate of improved climate of employment relations, it would be wrong to leave the law as it is. That would mean the law was unclear as tribunals and courts tried to reinterpret its meaning in the light of the judgment. Moreover, the government intends that as a matter of principle, trade union law should comply with the European Convention. The government does, however, reject arguments that the judgment's discussion of the right to be heard requires any changes to the statutory recognition procedure, the right to be accompanied, or industrial action law. The current law provides adequate means for unions to communicate and interact with employers on behalf of its members. The judgment makes clear that the European Court does not consider that the Convention requires any particular treatment of trade unions by employers. The government also considers that the judgment's passing references to the interests of the union do not require any overhaul of the law to enable unions to sue employers where their members have been discriminated against. The overriding focus of the Convention concerns the rights of individual people, not the entitlements of organisations. And then 3.2.12 on page 312, we've got the part that's underlined in the original. The law should explicitly prohibit inducements or bribes being made to trade union members to forego union rights. And that's why I say is particularly important here. In Kostal, this case, Kostal made no offer, it was just a pay rise. There was no foregoing of union rights. The workers had exactly the same union rights before the offer as after the offer. Their union rights were not diminished in any way whatsoever. Those particular employer behaviours that gave rise to Wilson and Palmer, they should be made unlawful. The government intends to make it unlawful for the employer to make an offer to an individual with the main purpose of inducing that person to relinquish rights to belong or not to belong to a union, to engage in trade union activities, the purpose proposed right to use union services. So we've got the word relinquish there, and then if we look at halfway down the paragraph, the result is it would be unlawful for employer to offer an inducement to union members in such a group to have their terms of employment determined outside the framework set by any existing collective bargaining arrangements. So in this case, did Kostal offer any inducement to the claimants to have their terms determined outside the framework of the recognition and procedural agreement? Answer no. Union members in this case, their terms continue to be determined by the framework set out by the recognition and procedural agreement. And there was no inducement to move anything outside of that agreement. Next, if we could go on to the explanatory notes. We deal with that in our case, and you can follow that through at page 80, 83, '84. The explanatory notes are at page 299. You'll see the language of the Wilson is reflected in the language of the explanatory notes. The particular passage is at 301 towards the bottom of the page. The heading of that section of the explanatory notes is inducement and detriments in respect of membership, etc. of independent trade unions. 193, the explanatory notes say that in July 2002, the European Court of Human Rights delivered its judgment in the case of Wilson and Palmer. The court concluded, over the page, that UK trade union law was incompatible with Article 11 of the European Convention on Human Rights, freedom of association, in that where a trade union was recognised by an employer for the purpose of collective bargaining about terms and conditions of a group of employees, the law did not prevent the employer from offering inducements to the employees in the group to persuade them to surrender their collective representation and have their terms settled instead by negotiations between each individual employee and the employer. The government believes that the principle underlying the decision of the court extends beyond the facts in Wilson and Palmer and is applicable to a number of other comparable circumstances. The purpose of sections 29 to 32 is therefore to secure that these provisions deal not only with the facts in Wilson and Palmer, but also with the other circumstances considered by the government to be comparable. So we have the government, and sorry, the explanatory note saying that the purpose is to prevent inducements to workers, groups of workers, to surrender their collective representation. Once again, in this case, nobody surrendered their collective representation. I'll take you next to sections 29 to 32 to show you what were the Wilson plus circumstances. Oh, sorry, Lord Legger.
Just quickly, sorry, Mr. Burns. If these notes were not available to the members of Parliament when they were voting on the bill, are they in fact admissible, or are they just an interpretation after the event?
Well,
what the government, which is not Parliament.
I think what the passage I referred to you in the, I mean, it shows what the proponents of the bill, a bit like intends, because effectively this is, as you say, it's the government saying what they intend. So it's a bit like Hansard. If there's something that's unclear or that's ambiguous, the proponents of the bill make it clear in the explanatory notes. But they are, yes, be treated with some caution as a tool to statute construction. They're not the statute.
But the difference is, in Hansard, you can listen to the minister, and if you don't like what he says, you can vote against the bill, at least in theory. Whereas the explanatory notes come too late. You've already cast your vote by then, and unless they were available to you, which they may have been for all I know at the time when people were looking at it.
I will see if we can work out whether the explanatory notes were attached to the bill as it passed through as an aid to the members knowing what they were voting on. But I don't know the answer off the top of my head. But I can take you to the act that's referred to here, which is the act which brought into force section 145B. It's at the main bundle at page 352. It's the Employment Relations Act 2004. And if you look at page 353, that takes you to the first of the sections that's referred to in the explanatory notes, section 29. And you can see that section 29 introduces section 145A, which is a Wilson plus, right not to have an offer made to him by his employer for the sole or main purpose of inducing the worker not to be a member or seek to be a member of the trade union, not to take part in activities of the trade union, not to make, at an appropriate time, use of trade union services. So there's one aspect of Wilson plus. We've then on page 354 got section 145B. You're familiar with that. The time limit, section 145C. Section 145D, which you're familiar with. Remedies at section 145A, 355. If you skip on to 358, you can see that Parliament also extended the protection of detriment for trade union membership, not just from employees, but to workers. So that's section 30. You skip on further to page 360, you'll see that the other part of Wilson Plus was section 146 was amended to add that you can't be dismissed for preventing or deterring the person from making use of trade union services or penalising them for making use of trade union services. And section 32 on page 362, the last part of Wilson Plus, was adding into section 152 a dismissal on grounds related to trade union membership or services, the addition that the person's made use of, made use of trade union services, or indeed failed to accept an offer made in contravention of 145A and B. So those are the Wilson Plus. Parliament did Wilson in section 145B, did Wilson Plus in section 145A, 146 and 152 amendments. I can take you next to Hansard, which both parties now refer to. The section in particular is at 282. And it's the when resolving ambiguity under Pepper and Hart, the minister who's proposing the bill can be looked up and nobody else. And it's Mr. Sutcliffe in this case, who's the minister proposing the bill. You see below 1045, the first part where Mr. Sutcliffe speaks. The second paragraph, he says, I'll start by looking at amendments which seek to amend the key rights provided by section clause 23. The clause stems from the 2002 judgment of the European Court of Human Rights in the Wilson and Palmer case, which held that aspects of our trade union law breached Article 11 of the European Convention. Amongst other things, clause 23 makes it unlawful to offer union members a bribe to forego key union rights. I can just pause there. You'll see once more there's the language of foregoing, relinquishing, surrendering. It was precisely such behaviour that gave rise to the Wilson and Palmer case, in which workers were offered a cash inducements to have their contractual terms determined outside the scope of a collective agreement. In drafting the clause, we've sought to create a clear entitlement for union members to use the services of their union, Wilson Plus. No longer will it be possible for individuals to be punished by their employers for asking their union to make representations on their behalf. Major advance. One goes down the page to the last contribution of Mr. Sutcliffe. We're dealing with inducements to workers to relinquish their individual rights to union membership and to take part in union activities. Proposed new section 145A creates a new right not to be offered bribes by their employer for the sole main purpose of inducing them not to leave or join a union. So you can see that in relation to section 145A, the minister uses the same sort of Wilson language of relinquishing or foregoing important union rights. The next section in Hansard is at page 287, and it explains the amendment, which we say conclusively explains the ambiguity that there might be over whether will not is intended to apply to recognised unions as well as unions seeking recognition. You'll see that Mr. Sutcliffe says there, this group of amendments makes two sets of changes to the clauses of the bill that implements the European Court's judgment in the case of Wilson and Palmer. Let me start with amendments 34, 35, 38. The Joint Committee on Human Rights has drawn attention to the fact that new section 145B, which would be inserted by clause 28, provides rights to the members of recognised unions only. It considers that in cases where the union is seeking recognition, new section 145B needs to provide comparable protections to ensure that members have the right not to be offered inducements by the employer for the purpose of securing that their terms will not be determined by collective agreement in the future. Having looked at the arguments put forward, having consulted the stakeholders, we concluded that the Joint Committee's analysis is correct. So to ensure our compliance with the judgment of the European Court of Human Rights, we believe that the scope of the new section should be extended. And to see the problem that the Minister was discussing there is seen at page 293. Because at page 293 you have the employment bill as was. And you can see that section 145B is a worker who is a member of an independent trade union which is recognised by his employer, no mention of unions seeking recognition yet, has the right not to have an offer made to him by his employer if acceptance of the offer together with the other workers' acceptance of offers which the union employer also makes to them would have the particular result, same wording as in the Act, and the employer's sole main purpose in making the offers is to achieve that result, again as in the Act. 2, the prohibitive result is that the worker's terms of employment, or any of those terms, will no longer be determined by collective agreement negotiated by or on behalf of the union. So the bill only referred to recognised unions like Unite and employers like Kostal, and the bill only had the words will no longer. The Hansard reveals why the words will not and the words union seeking recognition were added. Will not is intended by Parliament to apply only to unions seeking recognition. Will no longer is the phrase which was intended to apply to unions that are recognised. And all of the arguments of the claimants turn on will not, also applying to recognised unions. And you'll note that the Court of Appeal recognised that linguistically there were 3 options, absent my double future tense argument. 3 options: will not for unions seeking recognition, will no longer recognised unions, do also is the 3rd category, will not applies to recognised unions. The Court of Appeal said no, they didn't have the benefit of the draft bill because we hadn't managed to unearth it at that point. But this confirms that the Court of Appeal was spot on in my submission.
I missed the point at which a statement was made that the word will not would apply to unions applying for recognition, and that the words will no longer were to apply to unions which had already been recognised. Was that just interpolation?
In part, yes, but in part it's from what the Minister said. But my lady, so will not, we know applies, we can see it from the draft bill, will no longer applies to the recognised unions. If you go back to 287, you'll see that the last line of Mr. Sutcliffe's first paragraph is the comparable protections to ensure that members have the right not to be offered inducements by the employer for the purpose of seeking their terms will not be determined by collective agreement in the future. Therefore,
I haven't found that. Where is that?
So it's a middle of 287, just above having looked at the arguments,
Yes.
securing that their terms will not be determined by collective agreement. So the words that the Minister uses, will not be determined, in relation to unions seeking recognition, are the ones that then go into the amended bill and become the Act. Do you have that, my lady?
No, I don't. I only I have the paragraph beginning, having looked at the arguments.
So if you look at this, the last sentence, the committee considers that in cases where a union is seeking recognition, new section 145B needs to provide comparable protections to ensure that members have the right not to be offered inducements by the employer for the purpose of securing that their terms will not be determined by collective agreement in the future.
I see. You say that's on 287.
287. I ought to move on, lady, if you
Yes, certainly.
forgive me. I have not so much time left. If we can finally look at the method of collective bargaining order. I took you to the preamble before lunch. So in 2000, the Parliament passed the Trade Union Recognition Method of Collective Bargaining Order 2000. You'll recall from before lunch, I showed you the preamble which said that voluntary collective bargaining was the norm and not compulsory collective bargaining, and also that it was lawful for workers to agree terms individually with their employer even after collective bargaining had been imposed. Therefore, it's unlikely that 4 years later, Parliament intended to make it unlawful to make a direct offer just when there was collective bargaining. What Parliament intended was to make an offer unlawful if it was going to take away those fundamental human rights under Article 11. The claimants in their case, although it wasn't really, Mr. Siegel didn't take you to it this morning, suggested that the bargaining order, the prescriptive words of the bargaining order had something which you should take into account. Do bear in mind the words of the preamble that I showed you, that this is not the norm. That's at page 365. Voluntary is the norm. And finally, the claimants take you to paragraph 17 of the compulsory, the rare prescriptive collective bargaining where voluntary isn't possible and the CAC steps in and imposes it. They say, well, you should look at paragraph 17 to interpret section 145B. My first submission is you shouldn't look at section paragraph 17 as the norm, because as the preamble says, it's the exception. But in any event, all that paragraph 17 does, it says in the first line, the employer shall not vary the contractual terms affecting pay, hours or holidays of workers in the bargaining unit unless he has first discussed his proposals with the union. And that shows Parliament's level of commitment, which is the same as the European Court's level of commitment, a right to be heard, a right to discuss, not a right to prevail. And if you look at paragraph 18, paragraph 17 does not apply to terms in the contract of an individual worker where that worker has agreed that terms may be altered only by direct negotiation between the worker and the employer. So we've got actually, and it's still there to this day, the saving that a worker can agree terms by direct negotiation. The reason that doesn't offend against the 145B principle is that 145B is only where the offer to the individual worker is to take the terms out of the scope of collective bargaining. I deal with the section heading next in terms of the enacting materials. I perhaps don't need to do that any further. I mentioned it before lunchtime. It's inducements relating to collective bargaining, not anything further. You recall that that's entirely consistent with the words that are littered throughout the pre-enacting history. Inducements. It's about an offer which induces a worker to do something, to give up some rights. It's not about just giving a pay increase to a worker, as in this case. So, my lords, my lady, that's the pre-enacting history. And in our submission, the words of the draft bill in particular reveal the mischief of the act here, reveal the mischief of the words, and reveal that is not intended by Parliament to apply to unions who are recognised, just as the Court of Appeal decided. I'll deal briefly with the grounds of appeal raised by the claimants. First, it said that the Court of Appeal confused the prohibitive result with the main purpose test. There was no confusion. the prohibited result appears twice in the section, as you've seen. First, the offer must have the prohibited result, and second, the employer must have a purpose to achieve the prohibited result. Therefore, it's entirely permissible for the Court of Appeal to assess what the prohibited result means in both of those contexts, both in the context of achieving the prohibited result and where the purpose. And indeed, the EAT explained that in the section that we quote in our case at page 93 of the main bundle. EAT explains why the prohibited result appears twice and therefore can be considered in both of those places. The problem with the claimant's interpretation is explained or revealed by Mr. Segal talking about the underlying purpose. He says section 145B is directed at the underlying purpose. Well, not on its face, it's not. It asks not what's the underlying purpose of the employer, it asks what is the purpose of the employer. And that's why our argument is that the employer's purpose will be for the worker to accept its offer. And Mr. Segal says, oh, well, you look at the underlying purpose. Well, the claimants won't say that in cases. They'll say, no, the employer intended to achieve the purpose because they intended, on the claimant's construction, just for the offer to be accepted and for the terms to be determined at that moment by direct negotiation. And indeed, that is what the claimants pleaded in this case. Look at page 252. That's exactly the challenge that was put before Kostal and exactly what was accepted by the Employment Tribunal. The very mischief that Mr. Segal said isn't here was what holds Kostal below the waterline. You'll see at 252, it's the second page of the ET1, the particulars of claim in the tribunal. And you'll see paragraph 9 says, the effect of accepting the offer was that those clauses relating to SSP, statutory sick pay, Sunday overtime, breaks and pay, which were previously determined by collective agreement, negotiated by on behalf of the union, would no longer be. Instead, they would be determined by individual agreement negotiated directly with the individuals themselves. So that was what they pleaded the prohibited result was. What did they plead the purpose was? Go to section 2, page 253, the next page. Paragraph 17, the claimants assert the respondent's sole or main purpose was to achieve the outcome identified in paragraph 9. So they pleaded no more than the direct purpose. They didn't look at the underlying purpose, and indeed the tribunal didn't look at the underlying purpose. The underlying purpose was, as the Court of Appeal put forward, tolerably clear from the evidence and from the tribunal's decision. They wanted to motivate their workers. They wanted to make sure their workers got a Christmas bonus. They wanted to make sure that they had turn two 15-minute non-compliant breaks into one 30-minute break that was compliant with the working time directive. But the claimants directed the Employment Tribunal's attention to the immediate purpose and not the underlying purpose, and the Employment Tribunal accepted that and found against Kostal. Therefore, very difficult for the employer to get over the effective veto point by saying, oh, we've got an underlying purpose. And then turning to the effective veto argument, which is made in our case, and you'll have seen this at page 95 of the main bundle. This is something that we put forward in the hypothetical, and Mr. Segal rather conceded this point by saying, in response to my Lord Burrows, Well, there will be difficult cases. And that's exactly it. And he mentions the British Gas case, he mentions the British Airways case, cases in which the unions say that what the businesses were doing was a disgrace. It was outrageous. That the offers they were making in negotiations were unacceptable. And yet the business was saying, we need to do this in order to save our business from economic difficulties and circumstances. But the union will always be able to say that the purpose was to undermine the union's mandate. The union will always be able to say that it wasn't reasonable not to negotiate a bit more. The union will always be able to say that it was reasonable to pay 5% rather than 4%. And therefore, at the moment when the employer is making the offer, it has to take a massive risk. Do I risk going to the employment tribunal and put all my money on the one horse, which is that the tribunal will accept that my purpose is a reasonable purpose and rational, and I did do enough collective bargaining? Or what if the union and members show that a bit more collective bargaining would have been done? And that's what happened in this case. Although collective bargaining had finished, the tribunal were convinced that it was a whitewash. They were convinced that it wasn't enough. They thought that there should be more collective bargaining. And so the tribunal were making a value judgment. And that's the exact value judgment that the House of Lords, in the cases that Mr. Seagull took you to briefly for other parts, but I've referenced Duport Steels and Express newspapers in our case. The House of Lords made it absolutely clear the assessment of a trade dispute is out of bounds for the judiciary. And that's what the EAT's judgment would require the tribunal to do. Who's acting reasonably within the trade dispute? Who's acting reasonably within the negotiation? It's one thing for Mr. Seagull to say tribunals do day in, day out discuss reasonableness for one employee or the reason for discrimination or detriment. That's an entirely different question for a tribunal or court getting into the industrial arena and deciding whether an employer has negotiated enough, whether an employer is acting reasonably in only offering 4% and not 5%. And so we have this huge spectre which has hung over industrial relations over the last few years of the employer thinking, if I get this wrong, £4,000 per employee for big employers adds up to tens of millions of pounds. For one employer who's got a lot of huge unionised workforce, £100 million. And yet, as I put in the hypothetical, the difference between 1% and 2% could be just £1 million for the employer. The cost of getting this section 145B wrong, £21 million. And what Mr. Seagull says is there will be difficult cases. And that's what the effective veto is. The employer cannot possibly take the risk of £21 million penalty. It will always have to say, well, I'll just have to come, give a bit more to the union and reach the difference between 1% and 2%. My lords, I haven't quite got to the end of my submissions, but I realise that my time is up. I think I spent too much time dealing with the very useful and interesting questions. But if I could just flag 2 or 3 matters to you. First point on INEOS in the supplemental bundle. That's the case in which, as you'll see from the facts, INEOS went through what was called exhaustive collective bargaining over months and then made the offer. So that's a case in which collective bargaining was exhausted and then the offer, and the tribunal found that that was unlawful on the section 145B on the Kostal basis. So where you have done a lot of collective bargaining, you're still not allowed, says the INEOS tribunal, to make a direct offer. That's the problem with the INEOS case. Second, 238A, Mr. Seagull refers you to that about the unfair dismissal for protected industrial action. Can I just draw your attention to the section 238A(7), which takes the employment tribunal out of the industrial arena in the same way as Express newspapers and DuPont Steel. That's very important because 238A7 says that no regard should be had to the merits of the dispute. And what the EAT would be suggesting is that we would need to have regard to the merits of the dispute to find out whether the employer is acting reasonably. And finally, on Article 11, in order to see whether that I am correct about the correct analysis of the Article 11 freedom that Section 145B is there to protect, the union rights that have been talked about so many times, the passage that I have cited in the submissions, but that needs reading from start to finish, is at page 492, and it's Lord Justice Underhill going through all of the Article 11 authorities from Swedish engine drivers back in 1976 through DeMere and the expansion of collective bargaining because of the Turkish state's refusal to allow any collective bargaining for their civil servants, through to Unite the Union and the United Kingdom, the most up to date. And that goes to paragraph 45 at page 494, and that shows that the right to be heard is still the encapsulation of the collective bargaining right in Article 11, and no further than that. It doesn't go as far as a right to protect the union's mandate, as Mr. Segal would have you accept. And so for those reasons, I invite you to uphold the judgment of the Court of Appeal.
Thank you, Mr. Burns. Now, Mr. Segal.
My Lord, thank you. A number of times in his submissions, my learned friend said that if an employer does this, if an employer makes this offer, it will be in breach of the section on the appellant's case. No, there is no breach of section 145B unless the main purpose of any offer which has the prohibited result was to achieve that result. And throughout his submissions, he avoids that, thus making the same mistake with respect as did the Court of Appeal. And he makes a similarly misconceived argument by reference to the methods of collective bargaining order. He misses the point by referring to the wrong part of paragraph 17 of that order, and I simply refer you to our written case at paragraphs 35 to 36, the relevant part being, if there is a failure to resolve the issue at that meeting, then meetings shall be arranged and steps shall be taken in accordance with steps 5 and 6 of the above procedure. In other words, the legislation introduced by that Parliament at that time was all to strengthen the right to collectively bargain and to deter employers from stepping in and out of, to use the words of this tribunal, collective bargaining. We do not, however, as Lord Leggett pointed out, my own friend, say that 145B gives rise to co-determination, nor even at page 654 to Professor Toboggan-Ewing, as my learned friend wrongly implies. On the contrary, they contrast the right to co-determination in other countries, such as the USA, with the position under UK law. My Lord, I said before lunch that the respondent misrepresents the material facts. It continues to do so. Can I ask you to return to page 145? First point to make is there were not 57 union members out of 700. There are 57 claimants. The tribunal in its decision does not record the exact membership, but note at 5.4, 532 of the 700 had voted for Unite to be recognised. Secondly, and even more importantly, there were not negotiations either before or after the critical date of the 24th of November when Kostal put forward its avowedly non-negotiable deal. And the persistent attempt to present the facts differently is unhelpful. At paragraph 5.8 of the Tribunal's decision, they refer to what my learned friend says is the first negotiating meeting, and says that it is a meeting which took place, I'm picking it up about 4 lines from the bottom, regarding the anticipated pay negotiation. All it says about the next meeting in the next paragraph is that Kostal told the representatives of the workers that they are not interested in the negotiation process. They will make an offer, and that offer will be the offer. The deal was rejected in a ballot, and
I'm not sure how helpful this analysis is, Mr. Seagull, or where it really takes you. I mean, one way of negotiating is to say you're only going to get one offer, isn't it? I mean, which is a standard sort of negotiating tactic.
well,
However we like to look at it, this was a negotiation, but it was still ongoing when the separate offer was made, and those are the facts. It doesn't take much further to get into the ins and outs of it, does it? Who said what to whom?
Well, my lord, I agree with the subtext of the question, which is I don't need to demonstrate that there was no negotiation before the 29th of, the 24th of November, because, as my lord points out, the direct offers were made during that process. But with respect, I do resist the suggestion that the content of negotiation is very much at large, and that an employer who attends a meeting and simply says, I'm not going to negotiate, is negotiating. And even as far as the far back as the 1970s, in that Court of Appeal case to which I took you, perhaps it's worth revisiting it very briefly. From memory, I think it's page 422. No, it isn't. I'll find it. Yeah. It's in the supplementary bundle, that's why. I apologise. It's at 22, I apologise. At the supplementary bundle. It's been important, my lord, since the 1970s to know what collective bargaining is and to know whether employers are participating in it, because there are sanctions for not doing so. And the passage beginning at G, collective bargaining means negotiations relating to one or more of those matters, and that the last line of that page, that is to say, negotiating with a view to striking a bargain on an issue. That is, both before and certainly ever since that time, what has been understood to be the content of negotiation. And this tribunal, in reaching its decisions, in particular its decisions on the sole and main purpose, did rely on what had happened throughout those negotiations as a whole, as to whether, in this case, Kostal's sole and main purpose was to achieve the prohibited result. My learned friend, towards the beginning of his submission, spoke of compulsion. We say that he confuses two things. The first is whether workers can compel recognition of their union. And the Strasbourg Court has said so far that as long as workers have the right to seek to achieve voluntary recognition, the state is not in breach in not giving them the right to compulsory recognition. However, that should not be confused with the situation where a union is recognised and the extent to which the state can allow employers to undermine or frustrate the essential right to collective bargaining by making direct offers with inducements to workers. In those circumstances, the Strasbourg Court has said that is not permissible.
Mr. Seagull, can I just follow that through to your interpretation of 145B2, where a union is seeking recognition? I think you say that the prohibited result in 2 is what happens when the acceptance of a proposed term as a result of a direct offer varies the worker's contract in any way, rather than merely contains some contracting out mechanism for the future. But and you say, as I understand it, that applies as much to when an independent union is seeking recognition as it does to a union which is recognized. Now, I have some difficulty with that. If there is a pay negotiation going on at a time when a union is only seeking recognition, then, unless I misunderstood what goes on, there will necessarily be a direct offer process, or at least there may be, and it's not obvious why that should be a prohibited result. But it's easy to see why it should be a prohibited result. That direct negotiation contains inducements to the employees to contract out of collective bargaining at a time when the attempt to recognise has succeeded. The attempt to be recognised has succeeded.
Well, my lord, that isn't the structure, we say, of section 145B. If you return to 324.
Yes, I'm on it.
So the first qualifying condition is in the initial words of subsection 1.
Yeah.
The trade union is either recognised or seeking to be recognised. And my lord is asking about the second of those conditions.
Yes.
So you have a situation where an employer has unionised workers, but does not recognise their union for collective bargaining purposes, and the union, on behalf of its workers, has asked the employer to recognise it for collective bargaining purposes. The second qualifying condition is 1A read with 2. Acceptance of an offer, together with the other workers, would have the prohibited result, namely that the terms of employment, or any of them, will not or will no longer be determined by collective agreement. So far, my lord, and we're only on prohibited result, if there is a union seeking recognition for collective bargaining purposes, and if during that time the employer makes an offer to employees to induce them to agree their terms outside of, or if you prefer, before the agreement or potential agreement of recognition, then the second of the 3 criteria is met. There is a third, 145B1B. The employer's sole or main purpose in making the offers is to achieve that result. Now, my lord, if, for example,
the question I'm asking you is, why should an employee have a right not to have a direct offer made to him without going through collective bargaining if his union is still only seeking to be recognised? The employer is not committing any breach of anything by declining to recognise his union, and the offer doesn't contain a term that, if the union is recognised in due course, you won't rely on collective bargaining.
Because, my lord, and obviously I say this with greatest respect, that is what the statute says.
Yes, I just asked
because the statute focuses, my lord, on the purpose. And the statute says that if the union is seeking recognition for collective bargaining purposes, and if the employer, in order, I now paraphrase, to avoid that, makes offers directly to the workers, in other words, makes offers to the workers in order to achieve the result, that's its purpose, that they will not be collectively agreed, then the offer is in breach. Can I give 2 examples? If an employer offers, I think my learned friend said, £500 to agree terms outside of proposed collective bargaining arrangements, in this situation we're talking about, with the purpose, sole or main purpose, of avoiding them being subject to proposed collective bargaining arrangements. So let's imagine an evidential situation. It looks as though collective bargaining is going to be agreed or perhaps even forced on the employer in 3 months' time, and the employer says, outside of the normal annual negotiating cycle perhaps, we will give each of you £500 if you agree to the terms that we propose, knowing that they are never going to be agreed once collective bargaining, or if collective bargaining is agreed. That is unlawful. However, second example, if the offer is to agree a package of terms which must be implemented for commercial purposes within a limited time frame, say, well before the proposed collective bargaining arrangements can be entered into, it is not unlawful. So in other words, the same offer of terms, of the same terms, is lawful or unlawful in a situation where a union is seeking recognition for collective bargaining purposes, depending on the sole or main purpose of the offer. That is the statute. It is designed to deter employers from avoiding either proposed or existing collective bargaining arrangements for that reason. So, my Lord, I don't know if that answers, well, I think it does answer the question. It may not be the answer that my Lord finds to be the right answer.
You included in your answer the concept that the employer might be forced to recognise the union. How does that fit with your very helpful summary of the current Strasbourg jurisprudence, which you say
because my Lord, as well as voluntary recognition, if the union has, and I'm simplifying things, but if the union has majority support within a relevant bargaining unit and the employer still resists, then since the same government introduced what is now Schedule A1 to the 1992 Act, they can require the union to recognise, the employer to recognise the union.
Yeah, very well, thank you.
I'm grateful. So, can I then, sticking with the words of the statute, deal with this will not, will no longer distinction? And we do not accept the respondent's analysis of the tenses, what my learned friend referred to as his double futurity argument in section 145B. The easiest way to expose its fallacy is simply to read subsection 1A together with subsection 2. So the worker has the right not to have the offer made if acceptance of the offer would have the prohibited result that the worker's terms of employment will not or will no longer be determined by collective agreement. That is, with respect, simple, good English. I return to the point which we say is not determinative either way, namely the point that, in particular, my Lady Arden canvassed with my learned friend as to the respective scope of will not and will no longer. The respondent continues to be wrong to say that our case relies on will no longer being applicable on these facts. I made that clear, I thought, in submissions this morning. The respondent is also wrong to say that our case accepts that if will no longer were the only statutory words, in other words, if the draft bill had been enacted as you've read it, that they would be inapplicable in this case. That was also made clear this morning. At the risk of repetition, and by reference to page 157 in the judgment of the Employment Tribunal, and the penultimate paragraph on that page, the offers in this case were designed to achieve a final determination of certain terms of the claimant's contracts. If those offers had been accepted, and they were in nearly every case, eventually, terms with regard to Sunday overtime, daily breaks and pay would be governed by that bargain. Those terms would no longer be determined by collective agreement. Now, what my learned friend says in order to avoid that result is, well, the actual term as to pay, the actual term as to Sunday overtime wouldn't any longer be determined by collective agreement, but generically, the term as to pay or the term as to overtime would be if Kostal sat down with the union and collectively bargained next time round, or at least at some point in the future about that. In answer to my Lord Legate's question, why can will no longer not apply where terms have been agreed collectively and offers are made to agree those terms individually, which I fear my learned friend misunderstood, we say it can. As to the distinction, however, we do not accept that the respondent is right about the distinction between the two phrases. Like Lady Arden, we submit that it is unlikely that the bracketed and therefore subsidiary words "or will no longer" were intended to cover the more common situation where an employer seeks to undermine existing collective bargaining. And again, we do contrast the wording of subsection 1, bracket 324. A worker who is a member of an independent trade union which is recognised, comma or bracket, or seeking to be recognised, we contrast those with the words of subsection 2. We also, of course, take on board Lord Legate's point that it would have been quite easy to say expressly what my learned friend says is implied if that had been the intention. We say the better construction, partly for that reason, but anyway, is that the material distinction is between, on the one hand, will not, referring to the common situation where an employer offers new terms, for example, the terms of pay for newly introduced bank holiday working, as per the example that the Court of Appeal gave, which I discussed before lunch at the invitation of the court, or the new terms offered by the respondent in the present case for a 30-minute break, or, let us not forget, the term as to an entitlement to a Christmas bonus. It would be, we suggest, a very strained use of English to speak in the present case of acceptance of the offer having the result that the entitlement to a Christmas bonus will no longer be determined by collective agreement when it did not previously exist, as the respondent's analysis would require. So that is will not. Will no longer refers to the less common situation where an employer offers to remove or replace existing terms. For example, if the respondent had proposed as part of the pay deal to remove the entitlement to contractual sick pay. Now, we accept that if the offer is to vary a term dealing with a particular issue, say pay, it is possible to say either, as we do, that the new pay rate will not be determined by collective agreement, or, as my learned friend does, that the term as to pay will no longer be determined by collective agreement. It depends on whether one's talking about the specific term or the generic. But in all events, no connotation of permanence or long-term futurity arises in relation to either phrase. Now, as has been pointed out, will no longer is apposite to refer to existing terms which at the time of the offer have been collectively agreed. If something is no longer to be collectively agreed, there's an inference it has been in the past. Hence, no doubt, its use in the draft legislation on which the respondent relies. Whereas will not, which was added to the final legislation, but not, as one might have expected it to have been added if my learned friend's analysis is correct, is apposite to refer both to new terms in contracts where the terms have been previously collectively agreed, as I've just discussed, but also to new or varied terms in contracts where the terms have not previously been collectively agreed. Hence the need to include those words. My Lord.
Can I ask you what you say to one of the arguments that Mr. Burns made, which, if I understood it right, was that even on your interpretation, let's say will not applies to people already, or where the union's already recognised. But I understood him to argue that if the individual offer is, let's say, for a 2% pay rise for this year, even if that's accepted by the individual, it's not a situation where you can say that that will not be determined by collective agreement, as long as the negotiation is carrying on with the union, and there's at least a theoretical possibility that at the end of it, there might be a 3% for this year agreement, which you will still get the benefit of
Well, the short and simple answer to that point is that it completely ignores the statute, which requires the courts to determine whether there has been a breach at the time of the offer. And it requires the courts to determine whether at that time the offer, if accepted, would have the prohibited result, namely that that term will not or will no longer be determined by collective agreement. And with respect to my learned friend, the result of what he proposes in that regard that my Lord Legate has just put back to me would, to use the metaphor that the EAT used, reduce the efficacy of this section entirely to vanishing point. The question that the courts must deal with is not the suspension in form of collective bargaining, but whether these direct inducements are made outside of the existing, in this case, or proposed in another case, collective bargaining process. If the employer can simply make direct offers to workers whenever it wants to during a collective bargaining process, as long as it doesn't cancel future collective bargaining meetings, then the section has no teeth at all. So, my Lord, the point I was going to make finally, just by reference to the distinction between will no longer and will not, is that will not is apposite to, and I think the parties agree on this, to cater for the situation where recognition is at that stage only proposed, and therefore it was sensible to include it when the submission of the Human Rights Committee was taken into account and approved. Turning to section 145D, my learned friend says that subsections 4A and B are consistent with the respondent's case. They are. But what my learned friend doesn't answer is the point that they're entirely redundant on the respondent's case. And the case that my learned friend spoke some time talking to you about, of which I have no knowledge at all, which involves apparently British Airways making some supervisors into managers where both have their terms collectively agreed, I'd be keen to consider and perhaps make submissions if you're going to take it into account. But on what my learned friend says, there's no prohibited result. The terms of the relevant workers continue to be determined by collective agreement, just a different collective agreement, as would happen whenever anyone gets promoted from one collective bargaining unit to another. Without wishing to minimise the obvious importance of this case, the essential construction argument really is very simple. If there are proposed or existing collective bargaining arrangements and offers are made to individual workers to agree terms outside of those, that leads to the prohibited result. But that will be unlawful if and only if that was the main purpose of the offers. At 158 in the decision of the Employment Tribunal, in the second paragraph, we respectfully suggest they put it rather well when dealing with why they say they found that the purpose was an unlawful purpose. And going down to the next page, 159, picking it up 3 paragraphs above the word result. Further, we agree with Mr. Britton that the respondent's true intentions can be gleaned, etc., etc. The tribunal was absolutely alive to the fact that what they needed to look at was the underlying purpose or the true intentions. And it is no answer for my learned friend to say that in this case the workers have spoken because they were, well, bluntly, induced, bribed into accepting the individual offers. The workers spoke no less loudly in the Wilson case and the other cases considered with it. If I have time in the final minute, can I just make a point about explanatory notes?
Just 1 minute, Mr. Siegel. You lost a bit at the beginning.
I'm grateful. At page 299, first, can I deal with a specific question that Lord Levitt raised? No, the explanatory notes weren't in front of or endorsed by Parliament. One sees that from the first paragraph. But then going to 302 on the more substantive, the government believes that the principle underlying the decision of the court extends beyond the facts in Wilson and Palmer and is applicable to a number of other comparable circumstances. The purposes of sections 29 to 32, which include what becomes 145B, is therefore to secure that these provisions deal not only with the facts of Wilson and Palmer, but also other circumstances considered by the government to be comparable. As I say, that includes 145B, and what was supposed to cover, to be covered in addition to Wilson and Palmer is, as we saw, set out at 3.12 at page 312, including the two sentences which my learned friend decided not to read out. The respondent's submission on this boils down to, because Parliament went beyond Wilson in other parts of sections 29 to 32, it can't have meant to do so in section 145B. That is simply a non sequitur. My Lord, I hope that hasn't trespassed too much over the time.
Not at all, Mr. Siegel. You lost 5 minutes at the beginning. Thank you.
My Lord, can I just add one point in answer to the question? I've just looked again at the Employment Relations Bill 2003-2004, and the version that's accessible in an old version of the parliamentary database doesn't give you access to any explanatory notes that may have been with the bill. But I do see that generally explanatory notes are attached to bills. They're not just added when it becomes acts, but I can't secure the previous version of the explanatory notes. I'm sorry.
Thank you, Mr. Burns. Well, unless there are any questions, I don't think there are. And we are very grateful to counsel on both sides and to their supporting teams for the presentation of well thought through and detailed argument on this difficult question. And we will now go away and take time to think what is the right answer, and we'll obviously let you know as soon as we have done so. Thank you very much. The court is adjourned.